It is October 6th, 2022. I want to read through Proposal 3. For those that aren't aware, that's a proposal in the state of Michigan that will greatly expand abortion, and it would expand it within our state constitution. The consequences of this really can't be understated. I don't know of anywhere in the world where there would be a constitutional provision that is so expansive toward abortion. And I'm simply just going to read through it. I'll take some breaks, kind of just talking about what the implications of some of the language are. We've heard a lot of things going back and forth on, this proposal will do X, Y, and Z. I actually want to show, what the language says and where those conclusions are being derived from. Shouldn't take very long. It's only 232 words, so it's not very lengthy proposal, but the consequences are very, very significant. I guess before I jump into actually reading it, full disclosure, I am pro-life. I have voted for many different pro-life measures. I'm a Catholic. I'm not going to hide behind that. I will follow what Catholic moral teaching is when it comes to life issues. But that aside, that's not really the purpose of this video. I'm really just going to read through what the proposal is, and hopefully you can draw your own conclusions. I'm definitely voting no on this proposal, and I hope other people do as well. So let's just dive right in. Number 1, every individual has a fundamental right to reproductive freedom, which entails the right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. So probably the key words here to keep in mind right off the bat are the first two words where it says every individual. When you hear arguments about how this proposal would take away parental consent for an abortion, that's where that's derived from. There's no type of limits on age. So if a 13-year-old went to go get an abortion, there's no way that, from a legislative perspective, that we could regulate a type of requirement where a parent would have to be involved in that type of decision. So the proposal most definitely takes away parental consent. Another thing that's important to realize is it goes beyond abortion. The word sterilization's in there as well. Hormone treatments and other types of sex change operations are definitely on the rise, and they're trending to be kind of a growing issue, if you will, especially in kids. So this would most definitely take away a parent's right to know what's going on with their child. For something like sterilization, that's obviously a lifelong decision. For that to be made at a young age, that's something a parent most definitely would want to be involved on. So that's the implications of that first section. So I'm going to continue on here. An individual's right to reproductive freedom shall not be denied, burdened, nor infringed upon unless justified by a compelling state interest achieved by the least restrictive means. They used a defined term here, so I'm going to jump down to what a compelling state interest is. So number 4, for the purposes of this section, a state interest is compelling only if it is for the limited purpose of protecting the health of an individual seeking care consistent with accepted clinical standards of practice and evidence-based medicine, and does not infringe on that individual's autonomous decision making. So effectively what we have here is language that says a compelling state interest is that which is deemed acceptable by the abortion industry. So if I wanted to introduce a bill and have it passed by the chambers and signed into law, I would first need to go to the abortion industry to see if the regulation that is being proposed is acceptable by their own standards. So I don't know of any other industry that exists in the state government, at least, where people would tell the legislature what is acceptable for their own regulation. It's really backwards. It would lead to basically completely unregulated abortion in the state of Michigan. So the consequences of that are very significant. Continuing on, notwithstanding the above, the state may regulate the provision of abortion care after fetal viability, provided that in no circumstance shall the state prohibit an abortion that in the professional judgment of the attending healthcare professional is medically indicated to protect the life or physical or mental health of the pregnant individual. Again, there's another defined term there, so I'm going to jump down again to subsection 4 and just read what the definition of fetal viability means. Fetal viability means the point in pregnancy when, in the professional judgment of an attending healthcare professional and based on the particular facts of the case, there is a significant likelihood of the fetus's sustained survival outside the uterus without the application of extraordinary medical measures. So this really gets into fetal viability. I just read the definition there. So you've heard arguments that, well, this proposal would, protect the child, once it could be born outside the womb. It most definitely does not. It uses that language in the first half of this sentence, where it says the state may regulate the provision of abortion care after fetal viability. But the whole second half of that sentence totally guts the first half. It basically says if the healthcare professional, whoever that may be, if they think that it's in the best interest of the mother for either her physical or mental health, then the baby can be terminated. So that could be, if it's in the best interest of the mental health, that could be up to the moment of birth. So the language there is very significant. And then when you go into the definition of fetal viability, it's based up to the judgment of that health professional. The legislature wouldn't be able to say fetal viability begins at, pick a time, 20 weeks. We wouldn't be able to do that because the Constitution would enable that judgment to be made on the healthcare professional, not on the legislature. Number 2, the state shall not discriminate in the protection or enforcement of this fundamental right. Number 3, the state shall not penalize, prosecute, or otherwise take adverse action against an individual based on their actual, potential, perceived, or alleged pregnancy outcomes, including but not limited to miscarriage, stillbirth, or abortion. Nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. This section here, this part here, this part 3, completely removes liability for abortion providers. So the first sentence there really is about making sure that if an individual receives an abortion, they won't be prosecuted. But the second half, the second sentence here is completely about isolating the abortion provider from any type of criminal liability. As long as the woman would consent for an abortion if something were to go wrong, there's nothing the state can do to come in and penalize or add any type of criminal penalty for negligence. It's hard to express just how extreme that portion is. It's clear that this language was written by the abortion industry to protect the abortion industry. It's clearly not trying to do what's in the best interest of women, from my opinion here. Another thing to point out in here where it says, it says, or otherwise take adverse action against someone for aiding or assisting a pregnant individual. This is really confusing language. It's very, very broad. I think it's likely that this language could be interpreted as meaning that it doesn't have to be a physician that performs an abortion. Right now in the state of Michigan, if an abortion is going to be it's going to be conducted, it needs to be done by a doctor. This is very broad, and I think it could easily be interpreted as expanding it beyond that. So it's hard to understate the significance of the deregulation that would occur based on this language. So we've already read through part 4, which is the defined terms, so I'm just going to skip on to this last portion. So number 5, this section shall be self-executing. Any provision of this section held invalid shall be severable from the remaining portions of this section. This is pretty standard legal language. I see it in a lot of documents of bills that we vote on in the legislature. simply just means if something were to be deemed unconstitutional through the courts, just the provision that would be deemed unconstitutional would fall. The remaining aspects of the bill, would remain in effect. So that's it. It's really not that long of a proposal. It is extremely confusing and just very extreme overall. I can't think of a location in the world where, the human dignity of life would just be totally gutted to this extent. Like I said, I will be voting no on this. I think this, if it were to pass, would be a huge black mark for the state of Michigan. But I am hopeful. I am praying. I hope you are all praying, and let's stand together. And I hope you vote no on this proposal. So thank you, and God bless.